Welcome to Silicon Flatirons. My name is Pierre de Vries. I'm co-director of the Silicon Flatiron Spectrum Policy Initiative with Dale Hatfield. Welcome to our conference here today. Let me just start with the thank yous. Firstly, thank you to Dean Anaya and the law school for actually allowing us to use the space and allowing us to host this conference. Thank you very much to the sponsors. If you look in the back of your booklet, you will see the sponsors. Without them, this event wouldn't happen. We're very grateful for their support. My thanks to Phil Weiser, who currently is on sabbatical in Australia, but without him, this Silicon Flatirons would never have happened. He founded it. He continues to grow it. I want to say a particular thank you to all the panelists and moderators for the prep work that they've done and for giving us the time and for coming here today. I know of at least one person who was up at 4 a.m. DC time to actually get here today. So some people have come a long way already today. And last but not least, I'd like to thank Anna Noskasi and her team of staff and the student volunteers for making all of this stuff happen. Now, before we start with the conference proper, we have a Silicon Flatirons tradition, which is that we announce the winner of the student writing competition during the first conference of the academic year. And this conference is sponsored by Wilma Hale. And I'm hoping that we have Anne Lee from Wilma Hale, who's a CU alum, to present the award. Anne, are you here? If she's not here, she's running late. We will do this at the beginning of the next session after the break. So in order to get us started, I've asked Dale Hatfield to give us a 10-minute intro on enforcement. His work on enforcement, as on so many other things, has set the agenda. He's worked on the Commerce Spectrum Management Advisory Committee, CISMAC, on the FCC's Technological Advisory Council, the TAC, and also in a series of conversations we've had here in Silicon Flatirons going back at least to 2009. Nobody does a better job of getting people from really diverse backgrounds all on the same page with a complex technology question than Dale. So Dale, over to you.
Thank you, Pierre, and let me add my own welcome to all of you as well. What I would like to do in the next few minutes is provide some context for the balance of the conference and hide a few of my own personal concerns. Now, I tend to run on a little bit of time, so I'm counting on Pierre to give me a warning when I've talked too long. But at the highest level, I regard the FCC as having two fundamental or foundational roles, one of which is the management and protection of the radio spectrum environment upon which all of us are increasingly dependent. Said another way for emphasis, management and protection of the radio spectrum environment is not some small, obscure part of the agent's responsibility, but it's the guts of it. Stepping down one level from that highest level, managing the spectrum environment consists of four basic activities. We just did a little tutorial for the students. And those four sort of basic steps in spectrum management are allocating the spectrum for various uses, establishing technical and service rules to govern those uses of the spectrum, distributing the rights to operate within the allocation to particular individuals or entities, sometimes referred to as the assignment step, and fourth and finally, enforcing the technical and service rules established in the second step. Of course, many of those technical rules are aimed at controlling interference. Too often, in my opinion, the critical importance of the interference resolution and enforcement step in managing the spectrum environment is underappreciated, or worse yet, overlooked. And so is the failure to fully appreciate its rapidly changing nature. just as failing to enforce speed limits in a school zone endangers children. Failing to enforce spectrum rules endangers not only services that are critical to the nation's economic and social well-being, but to public safety, homeland security, and national defense. Having provided that background, let me proceed by laying out a series of hypotheses that I believe are true but need to be scrutinized by experts in forests such as these. And then after that, I'll touch on two of my particularly concerns. My first hypothesis or premise is that the United States is experiencing explosive growth in wireless devices and systems that must successfully operate not only in increasingly close proximity to one another in frequency, space, and time, but also to other electrical and electronic devices that unintentionally or incidentally emit or are susceptible to electromagnetic radiation. This increased densification of often disparate devices and systems increases the risk of disruptive and harmful interference. Second, many of the technological changes being made in radio systems to capture increased spectral efficiencies and generate additional spectrum capacity present challenges to traditional systems and techniques used to detect, identify, locate, mitigate, report, and where necessary, prosecute those responsible for causing harmful interference. Moreover, these underlying technological developments can enable deliberate, malicious, and potentially widely disruptive attacks on the nation's critical infrastructure, a point I will return to in a few minutes. Third, while these technological developments present a spectrum and measurement, direction finding, identification, other enforcement-related challenge, these same and related technological developments also hold the promise of increasing the efficiency and efficacy of interference resolution and enforcement activities, especially when combined with notions such as crowdsourcing and big data. Let me skip a little bit there and say that in the few minutes I have remaining, in an attempt to be provocative as I can, within that time, I'm going to focus my attention on one relatively narrow area of enforcement broadly defined, and that area is jamming and spoofing. Jamming, of course, refers to intentionally sending a signal that disrupts the operation of a receiving device. Spoofing refers to intentionally sending a fake signal meant to masquerade as an actual or legitimate signal. Within that relatively narrow area, I'm going to focus on malicious jamming and spoofing, where the intent is to disrupt authorized wireless communications and for nefarious purposes. It is perhaps obvious, but wireless systems inherently have a degree of openness and hence vulnerability, otherwise they wouldn't work. Malicious jamming and spoofing exploit that inherent openness. Technically, jamming is pretty easy to understand, but spoofing is a little more subtle. In brute force jamming, you just send an interfering signal that's more powerful and hence obscures the desired signal. But with spoofing, for example, a fake GPS signal could lead a navigation device in a vehicle to think that it is one place when it is actually in another, with potentially disastrous results. A fake telemetry signal could be used to tell a valve in a flood control system to open when it should really be closed, again with potentially disastrous results. A fake command and control signal could be used to divert the drone-delivered pizza you ordered and have it sent instead to some smart young hacker down the street. Just kidding. Maybe I'm not. Spoofing is particularly pernicious because unlike jamming, the signal looks and acts like a normal signal. You can kind of tell if your radio is being jammed. It's not so apparent if you're in your car and your GPS appears to be operating regularly, and it's not, whether it's locked onto a spoof signal. This is especially concerning to me when would be the use of spamming or spoofing by really bad guys such as non-state actors who actively seek to inflict harm, perhaps in conjunction with other activities aimed at major transportation hubs or large public gatherings. I could continue in my role of being a provocateur here and provide a list of developments that I believe increase the risk of intentional jamming, both malicious and non-malicious. Perhaps I can do that maybe in the wrap-up session. But let me stop now and just say that I'm looking forward to the remainder of the conference and learning more about these and other issues from the incredible group of experts that we assembled here this afternoon.
So I was fortunate enough to actually see Dale's notes, and I wish that we had more time for Dale. I'm hoping to persuade him to actually allow us to publish those notes up on the event webpage where you'll all be able to get the benefit from them. So let's actually just skip back before we set up for the panel to the Student Writing Competition Award. I'd like to invite Ann Lee from WilmerHale to present that award, a CU alum.
Hi, thank you. Good afternoon. My name is Ann Lee. I'm an intellectual property at WilmerHale in Denver. I have the honor today to present the winner of the WilmerHale Writing Competition. Each year, we've been accepting submissions from students of papers written about the topics of technology and law. And we sponsor this contest in order to promote and encourage among the students the continued pursuit of research, planning, organization, writing, and editing of scholarly papers in this field. The winner receives a check for $500 and an opportunity for publication in the Colorado Technology Law Journal, which was previously known as JTHTL, published by CU Law. This year marks the 14th year of this contest and the second year that WilmerHale has sponsored. A panel of attorneys at WilmerHale read and judged all the papers. We thoroughly enjoyed reading the submissions, and it was really challenging to pick a winner, but as all judges must do, we picked one. So I am pleased to announce that the winner of this year's WilmerHale Writing Competition is Stephanie Logan Drum. If you could come up. So Stephanie wrote a paper entitled Cyber Insecurity, How FTC versus Wyndham Fall Short and Why the United States Still Needs Federal Legislation Addressing Minimum Corporate Cybersecurity Standards. This paper examines the country's current regulatory framework for cybersecurity and argues for federal cybersecurity regulation. We commend Stephanie for the research and thought that went into her paper. And please, once again, join me in congratulating Stephanie for her paper. Thank you.
Thank you very much. And if the panel, everybody whose name appears on the front, if you would come up so that we can start with the next panel. In the meantime, while the panelists are coming up, just a few words on admin and administration. The first thing is that at Flatirons, because we're more interested in what the panelists actually have to say than in what they did that got them here to say it. We don't rehearse their bios. They're in your booklet, so feel free to look them up there. The second is we will have 2 breaks. Breaks, in my book, are the best part of the conference, but I'm going to be bad cop, and I'll try and start up promptly. You're going to hate me for this because I'll be interrupting your conversations, but that'll help us stay on time. And the last thing, I'm really happy to say that we have a quiet room for this conference. That's something for the introverts amongst us. So if you need a break, if you go to coming into this courtroom just to the right, there's another little courtroom. It's marked quiet room. It's the introverts' refuge. No eye contact, no talking, just a place to recharge your batteries. So with that, let's start with the first panel. It's being moderated by Rebecca Dorch, who is a senior spectrum policy analyst at the Institute for Telecommunication Sciences of the NTIA, the Department of Commerce, just down the road. She's a lawyer. Probably of all the people that you're going to hear from today, she has more hands-on experience with enforcement than anybody else, having spent 12 years in the field with the FCC, most recently, before she joined ITS, being the director of the Western region of the FCC Enforcement Bureau in Denver. Please take it away.
Thank you. Welcome to the first panel for this afternoon. As Pierre indicated, the information on all the panelists here are in the programs, but I would like to at least identify them, each one briefly. Charles Cooper right here is currently the acting director of the Enforcement Bureau for the Federal Communications Commission. And Anna Gomez is a partner at Wiley Rein. And you have, sorry, and she has both prior Federal Communications Commission and NTIA experience. Charla Rath, Vice President of Wireless Policy Development at Verizon, also has prior experience at FCC and NTIA. And Fred Wentworth, who is a Senior Vice President of Freedom Technologies, also significant prior experience at NTIA. So we have a lot of both private sector and government experience here. So I'd like to start out with, the title of our panel is Taking Stock Progress and Challenges. So we're going to start with some progress, and then I'll ask each one of the panelists a question on progress that we've made on interference issues and spectrum enforcement, and then move on to some challenges. And one of the items that was identified in the summary work, or the summary material for the panel, had to do with, in terms of a progress, was the efforts, significant effort and progress that has been made with respect to voluntary inter-party coordination and collaboration to prevent and resolve most interference. So they wouldn't necessarily have to rely on the FCC or rely on government's solutions, but and actually have the private sector have some significant involvement in making those sorts of agreements. So I'd like to turn my first question to Charla, and building upon your experience with the private sector and the agreements that you have brokered and been involved with between individual entities that are involved in the communications infrastructure. What lessons learned from those sorts of private collaborative agreements do you think that we should be taking forward as to how to quickly resolve interference issues in our new spectrum sharing scenarios?
Yeah, thanks, Rebecca. And I'd also first like to thank both Pierre and Dale, since this is, as many people are aware, this is a series that has been, what is it, since 2009, is it? Yeah. And each one, I think, is very interesting because it'll explore things that we maybe are starting to think about or haven't thought about quite as well. And this one, I hope all of you go back and look at the 2013 event, which had a lot of really good things attached to it. And in fact, it was sort of fun for me because I went back and looked at it, and some of the things that are said there, even things have changed in 3 years. Which I'm not going to go into too much detail, but there is an entire discussion of unlicensed that has changed remarkably since we and other carriers and Qualcomm and others have been trying to introduce LTE in the 5 gigahertz band. So just read it. We're not going to talk about that right now. But one of the things, but I suspect it will come up sooner or later in this conference, one of the things that, and I think people who, certainly Pierre is probably sick and tired of hearing me say this, and I know Dale is, because you were the first person I had the conversation about what happened back, say maybe 20 years ago. The commission decided when it adopted the rules for PCS that it was going to take a different approach than it did for cellular. And in cellular, everything was very regulated, and over time that's changed as well. But PCS, they set out some high-level technical rules, and then they basically told us, if you have problems, at the borders, solve them, and don't tell us. And so it's sort of interesting. The commission can come to us if it wants those, but it doesn't ask for any of these agreements. And these agreements, a lot of people talk about it. There was an entire discussion on this issue, I think, a couple of years ago, about how, well, that's just like-minded individuals getting together and having a conversation, and they all agree. Well, let me tell you, it isn't always like that. Sometimes it is. You launch in a network area, and you know that the geographic boundary, for example, doesn't quite suit the way you're going to want to need to serve your community. So you talk to whoever has that adjacent license, and you come up with an agreement. And you actually would do that ahead of time, usually. But there are also situations where, I'm sure a lot of people in the room here are probably RF engineers or know it pretty well, where if you really, which I love, is you look at our map of where our signal is and what we do to clean it up to show the world versus the map that we actually have, which has, spurious emissions just, heading down, almost looking like they head down a highway. But, those are the kinds of things we have to resolve too. And, Charles, you may actually know the answer to this question, but how many of these do you actually ever even see?
You're talking about the public maps versus the carrier maps?
No, I'm talking about the agreements and the things that we do, and have been doing for years in negotiations with other carriers.
I don't think I've ever seen one.
Yeah, that's what I was hoping you'd say that. So, the issue is how does that apply in different situations? And I think one of the things that Rebecca had asked me to talk about is how does it apply when you're, it may not work as well when you have entities that have different, you have one that's already operating, or an incumbent versus a new entrant. Some of those things wouldn't move as well, and maybe government, federal users, and non-federal users. But what I have always felt, and I think the commission has continued to try to do this, and CSMAC has actually spent a lot of time talking about it too. CSMAC, the Commerce Spectrum Management Advisory Committee. You did not say that we had to be careful with acronyms at the beginning. Yes. Yeah. So sorry, I know. I feel like whenever I'm in this room, I have to be careful about acronyms. But in any event, I think that there is more opportunity along these lines to give more authority directly to the, in one case maybe those who hold the assignment versus those who hold the license. There was some of that, obviously, in early days in the 700 megahertz licensing with Channel 52. I just think more of that kind of thing would be very good, and it does help get things resolved, much more quickly. Again, high level, I recognize that could be a full day, full half-day conversation about how you would work that through, but anyway, that's my long answer to the short question.
Thank you, Charla. Those agreements have to do with how folks share and work in the same environments, but we also have the issues of interference that do come up every once in a while, notwithstanding those sorts of private agreements and the efforts that have been made in that realm. One of the significant efforts that I've seen in the last several years is the work that Pierre DeVries has done on harms claims threshold and risk-informed interference assessment, and I think that's made a significant impact on the discussion on spectrum sharing and how we go forward. And I wanted to turn to Anna and ask her, in your experience, because you've been through with the FCC and NTIA and now in representing clients, are you seeing in the work that you're doing now an increase in the discussion of a change in the discussion from harmful interference to more discussion about a nuanced analysis based upon Pierre's work and more discussions of changing from worst case scenarios to the risk-informed assessments?
Yeah, so I actually read Pierre's paper a year ago because we talked about it last year. Yes, thank you, Pierre, and thank you, Dale, for allowing me the opportunity to speak here today. So bottom line, I would say, is that the players want to have confidence that the spectrum managers can resolve whatever interference issues have arisen. And so I do think there is a great deal of discussion of a more risk-based type of regime for resolving interference, but you're still seeing parties typically want to look at worst-case modeling versus real-world scenarios. If you think of all the high-profile issues that we have going on at the Commission right now, that's really what they're talking about. Now, with the advance of more sharing, hopefully that mindset will change, but it's still early in the game. But at least for today, I think it's more of a theoretical discussion as opposed to what's happening in the real world.
Well, that's unfortunate.
I know.
I was
Now, extrapolating this to other parts of government, you are seeing this type of analysis being done. The FDA, the Federal Drug Administration, sorry, acronym, is looking at more of a risk-based analysis and determining how much to regulate. The Federal Aviation Administration, with unmanned aircraft systems, is specifically has asked its rulemaking committees to look at a risk-based regulatory regime for unmanned aircraft systems, whereas it's basically, if it falls on your head, is it going to kill you? And if it's not, then maybe we can allow more flexibility. So I think it's permeating government. It just hasn't quite hit the spectrum realm in day-to-day negotiations and discussions. And it's, I mean, when you think about it, I'm going to be conservative in what I'm going to demand for protecting my own interests. And that's essentially where we usually see at least the beginning of the negotiations. When they start speaking in private, that's when you start seeing what is more of a, well, okay, what's really going on here and what can we live with?
Yeah. And I would also say that when you are on both sides of the issue, that's when you actually start to think about it a little differently, I think.
Remember when Sprint was an ILEC and a long-distance provider? They were very good at finding that middle ground.
Well, my assumption was that you would say, yes, it is making a difference and people are engaging in much more evidence-based sort of discussions to be able to inform the risk assessments. And that was going to give me my opportunity to turn to Charles because of the fact that,
what happens when you have a substitute? I apologize.
It's good. So gathering evidence to be able to put into the assessments of interference when you're doing, whether it's worst case or risk informed, the tools and the technologies that are available today are significantly improved from what they have been in the past. So that's one of the other areas of progress in the manufacturers of the technology and the tools that we're using. With the FCC's modernization, one of the commitments was that additional tools and more advanced tools would be available to the field agents to be able to resolve the more complex and difficult interference issues that you were asked to go out and find and resolve. And so I wanted to ask you if you could talk a little bit about what some of those tools and capabilities are that the FCC is going to provide for the field agents. And then as a kind of follow-on on that one, there's in the past, at least when I was working in the Enforcement Bureau, there was a lot of discussion about direction finding as being an art. And I'm wondering, with the advancement of the tools and the capabilities and the ability of the equipment to engage in both monitoring, detection, identification, and classification, if direction finding may become more of a science than an art in the future.
Well, good question. And thank you, Rebecca and Pierre and Dale, for allowing me to be here today. So the FCC field, kind of taking stock of where we are today. In the preceding 12 months, we've gone through a modernization process and continuing to go through that, hoping to wrap that up by January of the coming year. As part of that, there's a promise of some equipment, and we're also making some modifications to some offices. And we've also been more focused on RF interference mitigation and resolution. So in the past 12 months, we've had about 1,000 investigations that the field has run, mostly in the interference world, and about 350 of those were for our public safety partners. Looking at that 350 number, about half of those were for our state and local parties, for example, the local sheriff, the local police, and the other half were for our federal partners, principally the FAA with interference to their air-to-ground communications, helping them resolve some issues. along with their navigational aids and radar units. And one of the other important federal partners is the U.S. Coast Guard, in particular their Maritime 911 system, the Channel 16, which a lot of boaters use to communicate with the Coast Guard in the event of an emergency. So that takes care of our universe of public safety, and certainly our most important customer, if you will, for the field. The others tend to be more in the commercial industrial realm. They deal with cellular interference, not necessarily the agreements that was discussed a little bit earlier, but perhaps from incidental or unintentional emitters in the cellular band. Land mobile, still important use with the two-way radios, not only for public safety, but also in a lot of urbanized areas. Broadcasters and interference to their stations, both from unintentional and also pirate broadcasters, and amateur radios. So that's, for the most part, that's our universe of complaints that we work in. So looking at it from a tool perspective, I think we can put those in 2 to 3 buckets. And it kind of depends on the interference profile that we're looking at. If it's what we call a continuous duty or something that's on 24/7, it tends to be a little bit easier to find because given enough time and resources, you can find it. It's always there. And if you further bifurcate that, you have kind of the low-powered and high-powered. So the continuous duty, high-powered, if you look on the broadcaster side, a pirate broadcaster, that's an obvious one. Kind of high-powered on the air continuously. Kind of going down from there, you may have a bidirectional amplifier or signal booster that's commonly used in buildings to reamplify public safety spectrum or cellular spectrum. Sometimes those begin to oscillate and go into an issue and become to cause interference, perhaps to a broad swath of spectrum. And interference to the FAA could also be considered more of the high-powered continuous duty, maybe interference from broadcasters, a third-order intermod at frequencies above 108 megahertz. So that takes care of the high end. On the low-powered end, where your RF visibility is a lot lower, the interference tends to be more from unintentional emitters. These could be from equipment that's not operating right, to lighting issues from electronic ballast for fluorescent lights to LED lighting. So that's the continuous duty. Again, kind of easier to solve and enforce from that perspective. The other one, and the more difficult one, is the intermittent. And what I mean by intermittent is the RF carrier only comes on periodically, or hopefully periodically. Sometimes it's random as well. And I know when I was in LA running that office, that was the worst call I wanted to get, was some public safety entity saying, I have something happening on my public safety channel. It comes on 1 or 2 days a week, but yet when it does, it's causing harmful interference. Knowing that you have to potentially put a lot of resources into this, and it's still kind of a question if that's going to be solved. But still on the intermittent side, you still have with the high-powered and low-powered. On the high-powered, you may have, as I mentioned, with the public safety and a hoax operator on the public safety channel, that still occurs. And on the flip side, on the low-powered side, you would have mostly malfunctioning unintentional emitters. So those are the 2 buckets. The third bucket that's become an increasingly challenging area is the shared spectrum, particularly the 5 gigahertz with the unlicensed devices protecting the primary incumbents in that spectrum. And I suspect we'll be touching on that.
Yeah, we'll be touching on the challenges next.
So I'll hold the thoughts on there. But as for the tools, so a lot of this can be done with our direction finding vehicles. These are vehicles that have spectrum tools in them and directional antennas that can essentially point the driver and the operator of the vehicle in the direction where to go. That last mile, as in the telecom sense, or that last few hundred feet, we typically resort to a spectrum analyzer. Now, of course, we're using more real-time analyzers that are able to capture the spectrum in real time rather than historically the spectrum analyzers. The benefit for the real time is allowing you to catch those transient or those intermittent signals. Coupled with the use of an appropriate gain antenna, an RF filter, preamplifier, and you've got a pretty good setup to go in and actually maybe even go into someone's house or someone's business to find that device. So that takes us where we are today. As part of the modernization, we have formed within the FCC field office a Field Technical Advisory Committee, to use an acronym, FTAC. This committee produced an RFI that was issued a few months ago, looking for commercial off-the-shelf DF systems that can essentially solve those intermittent interference cases, because those are the most resource intensive. So you have to go where the interference is. The interference is trending toward more low-powered emitters. So being able to deploy those spectrum sensors with the DF capability to be able to be self-contained, in other words, have power, have internet connectivity, so the data obtained from those devices can be fed back to the FCC agents for analysis. So as I mentioned, that RFI was issued. We've had several commercial companies provide responses. We're reviewing them, and I think we're going to select about 3 to 4 of them to do evaluations at our equipment development group in Georgia a little bit later on. So that's what we're looking for on the board. To your last question, dealing with the art versus science, that's a good question because, you know, in the field, it kind of gets messy. You're not in an anechoic chamber where you have a very strict operating environment. You're exposed to a lot of multipath. Your equipment is subject to brute force overload. So I think there's always going to be a tension between the two, but certainly from an engineering side, you want to go to more of an objective rather than a subjective way would be the goal.
Thank you. So you've obviously pointed out some of the issues that we still have with finding interference and the necessity to be able to have some systems that can help detect it. So let me turn to Fred for a second. There significant amount, and this is another area where I think there's been some positive work. The multi-stakeholder groups of both the Federal Communications Commission's Technological Advisory Council and the NTIA's Commerce Spectrum Management Advisory Committee have come up with a number of different. What is?
Speaking of interference.
You know what? If I turn it off and on, we'll know if it's mine.
Okay. I'm sorry, that was distracting for a second. So.
Yeah, really.
Thank you.
They're unlicensed devices.
Will the FCC please make sure that we don't have interference?
Interference here, right, yes.
I'll bring out my rule book here.
Yeah.
Okay. So some of the work that the advisory committees have come up with, and I think that there's a general consensus that we really do in spectrum sharing and spectrum management, we need to have a fast and efficient sort of rapid ways of being able to monitor, identify, classify, and detect and mitigate interference. There's a consensus, I think, that ex-ante rules need to be exist to help facilitate identification of the transmitters, which will be the source of interference, and that technical solutions that would involve self-enforcing and non-interference capabilities being built into equipment. So given what Charles has said and what the advisory committees and the multi-stakeholder groups have come up with in this area, one of the questions that I want to direct specifically to you is having to do with whether or not the technical solutions will be sufficient. What your colleague, Janice Obuchowski, who has been very active on the CSMAC for years, is kind of famous for saying without enforcement, these technical solutions will not get us anywhere. And that strong enforcement is absolutely necessary in any event to curb business behavior. And given your past experience with spectrum management from the federal government side, I'd like you to focus on sort of your thoughts on where the concerns are in the spectrum management for spectrum sharing purposes as to what mechanisms for enforcement are the federal incumbents most concerned about in this context.
Well, I think the biggest concern of any party is the party that has the frequency spectrum being used. When there's a new entrant that walks into the auditorium, the question is what effects is it going to have on the current user's capability? And the government has a lot of assets that are very important. So when it comes down to sharing, the question is what steps will be taken to ensure that their operations will not fail if the incumbent comes in or if the new party comes in. So we go through a whole lot of rulemaking that sets the stage for the rules and the procedures that will be used to prevent that from happening. And you would say, well, if that's the case, there shouldn't be any problem. But there's always things one doesn't necessarily see that becomes a reality. One happens to be the analytical tools that set up the regulations in the beginning. It would be great if we had a single agreed to analytical capability that clearly distinguished exactly what the interference threshold would be. And then exactly how you would overcome it if it did happen. That would be great. But we have as many analytical capabilities available as we have people in this room. And if I give you a problem and you all attempt to solve it, chances are pretty good you're all going to come up with a different answer, and some will be significant. But hopefully, through the rulemaking process, we get around that to some degree. Now, a couple of things that have happened that have aided in that, one is the government's and NTIA's Commercial Spectrum Management Advisory Committee. And they were asked a variety of questions associated with sharing. And they've provided over the last 2 or 3 years a tremendous amount of information. In other words, linkage between the commercial sector and the government sector to come up with these agreed to rules, as well as come up with analytical capabilities to show that that's the best case. And many of those things are a prerequisite for sharing, especially in the recent areas like 3.5 gigahertz, 5 gigahertz, the 1695 to 1710, the 1755 to 1780. If you'll notice, a theme throughout all of those is that protection zones are established for those you want to protect. If the incumbent comes into those zones, then there's a procedure for coordination. And they set up such things as portals in order for the carriers, for example, to come in and say, this is my request to operate in that protection area. And that is then evaluated by those that are being protected, and feedback is provided. The carrier came in and had an analytical capability that they used to say, this is what we think will fit. The incumbent has an analytical capability to check and see if it will. And then they resolve that difference. That same thing is going to be applied to the 1695 to 1780. And the interesting thing is that agreements will be made at the lowest level. The carrier that's actually supplying the frequencies for the handsets that are already out there. And the parties that are operating the incumbent, whether it be a radar or a base station that's receiving information from satellites. That party, those two parties will be working together. Now you say, geez, is that new? No. Actually, it's been going on for a long time. The parties that are in the environment, I'm not talking about NTIA and the FCC. I'm talking about Verizon and the Department of Interior or the Department of Defense. Those are the people at the local level are saying, hey, I think I'm receiving a little interference. Do you think we could make some adjustment there? And it happens. And it happens all the time. And the tighter the agreements, then the better it'll operate. And that seems to be our system, and it looks as though it's going to be the answer to the sharing part. Now let me just make another point about sharing. For all practical purposes, frequency assignment in the past has been you get this frequency, and you get this frequency, and so forth. And we dole out the frequencies one at a time so that no party within the proximity of the other has the same frequency. And things seem to work out okay. But we're finding that we just don't have enough of exclusive use of a frequency to do that. And so now, we're now addressing in the last, let's say, 8 or 10 years anyway, time. We'll let the same parties have the same frequency, but you get it some of the time, and then I get it some of the time. Well, how do we actually work that out? Especially when I'm not transmitting or receiving for the next 30 milliseconds, and you can have it. And then you can use it, and then I can get it back, and so forth. How do you go about doing that? And that's what technology is attempting to solve. And the same thing goes for the policy side of things as well.
I think these are, you're pointing out some of the, we're kind of moving into our challenges section.
So that's what's coming up in the forefront, and it's the new thing. Time is the new thing that we're addressing. And I think all in all, let's face it, let's see, the COM Act in 1934, that's 82 years ago. That was our first nail about enforcement, was there. And we've come a long, long way with enforcement that, by the way, occurs every single day. It occurs at NTIA every single day, where a new assignment comes in, and they gauge that assignment against the rules that apply to it and everybody else who's in the environment. And that's enforcement right there, and it happens hundreds of times a day, every day.
As Charles had mentioned, and then the number that they have, in cases even that they have actually gone out on in the last year. So one of the things that you mentioned in terms of the environment takes us into one of the challenges that I'd like for us to talk about a little bit, and that is the issue of the noise floor. There had been anecdotal evidence for years about the noise floor being raised with all the different devices that are out there, and that it's affecting both the design of systems and how systems are being deployed. This summer, thanks to the FCC's Technological Advisory Council, the FCC issued a technical inquiry on noise floor, asking for empirical evidence and information to look at the actual noise floor and see what the situation really is. And so I'd like to not direct to any one person, but I'd like to throw it out to the panel here to talk about how you foresee that technical inquiry playing out, and do you see that there will potentially be some ex-ante rules that may come out of it, some ex-post enforcement that might be facilitated because of the information that technical inquiry comes in, or how it actually might impact spectrum sharing if we actually get the good empirical data on the noise floor. Who'd like to take the first stab at that one?
I'll start off.
Thank you, Anna.
And I'll be brief. So the inquiry is a pretty broad inquiry, but in the end, what it seems to me is asking about is whether we should do measurements. Mm-hmm. And so that's the initial question. If the answer is yes, then that may lead to gathering data that leads to help with enforcement and with spectrum sharing and all that. But until we decide to do the measurements and they actually gather the data, I think it's difficult to respond to that. It's a little theoretical. So first is the question is, do we do these measurements, and how do we do them?
Yeah, what was interesting to me is when you look at a lot of the responses, first off, there was, a decade ago or 15 years ago, I think the answer would have been very different. And it also is very band specific. It depends on where you are, whether there's an issue or not. But what I found very interesting is also sort of a focus on good engineering practice that was discussed, and that maybe in addition to measuring, and we, one of the things we said is we would actually love to see some of these things. I mean, we deal a lot with, that's basically what you're doing when you are running a network, is you're dealing with all sorts of, you're running the network, but you're also dealing with a lot of interference issues that come up, as well as building it, as I know Charles is well aware of, what, building the 700 megahertz part of our network, dealing with a lot of the LED lights and the issues and the interference that was created there. But with one of the things that several commenters just mentioned is maybe honing in on what good engineering practice really is. And the concern, yes, we think the noise floor may be increasing. There are also things like ballasts in fluorescent lights that get evaluated as a single thing, and there are thousands of them in an office building. So that we actually deal a lot with interference from things like that. So I think combined with this idea of measurement, there are also I'm sure we would like to see the FCC move forward and actually maybe open a couple of proceedings on looking at this, particularly as we think of an IoT world, where if we really are going to be in this environment where we have all sorts of emitting devices everywhere around us, I think it's a perfect time to stop and think and really spend some time looking at just what are the appropriate, what's the appropriate regulatory structure. I mean, those of us who've been around a long time, unlicensed was certainly not, I don't think anybody really envisioned what actually happened with unlicensed. Maybe there, I can think.
Pierre did probably.
And
Dale did.
I was Pierre and Dale, and I was also going to say Mike Marcus would probably
Yeah.
say that. But as you really think it through and you think about what happened in that band, in those bands, they're being used in ways that I don't think anybody ever really had envisioned. And so now we're talking about doing that on probably by a factor. And, if it's going to work, I think we need to really understand what it is that we're dealing with, getting to measurements, but also maybe, open it up and say, is there a different regulatory regime that we need to be?
Yeah, I really like the way that Dale Hatfield, sorry, I'm interrupting, started off our session talking about sort of the 4 elements of spectrum management, allocation, service and technical rules, something else, and enforcement. Forgot what the 4th one. Assignment, right.
Licensing.
Thank you, license. Oh yeah, that part, the licensing part. But and then you need to think about each of the players. You just mentioned good engineering practices. That's what you expect folks to do in the non-regulatory, non-ex ante regulation regime. And then you're trying to find the right balance on the regulatory side so that you have sufficient clarity for all of the players, including the device manufacturers and the systems developers, so that they have an idea of how to develop their systems and their devices so that they can respond to a certain level of noise. And then the importance of FCC enforcement when it is in fact time for the regulators to step in and say, okay, we really do have an issue here. We need to figure out how to fix it beyond the public-private negotiations that take place every day, including with the federal government. So just to lay that out in terms of how Dale was laying it out, I thought was a very nice way to start this discussion.
Well, and sorry
I'm
to
done.
interrupt you, but also I think one thing that is probably obvious is that when I'm talking about negotiations, there's somebody to negotiate with.
Right.
And a lot of these devices, you're not going to negotiate with the device. It's that process needs to take place before it's actually even in the field.
And both of your comments bring up 2 other of the big sort of challenges that I think that we're facing, and one of them is the issue of all the unlicensed emitters that are out there, and we can talk about that, but also aggregate emitters, because as you say, who are you going to negotiate with if your problem is not that you've got one interferer, but that you have a noise floor that is raised up, or that you've got an aggregate amount of devices out there that it's not the one that's causing the problem. And as Charles had said, it was easy when they found a constant on signal, but what do you do with an aggregate environment? Now the NTIA ITS is actually modeling aggregate issues right now, but it is a challenge, I think, for enforcement. And so why don't we go to that one first and talk about, from your perspectives, how will we deal with? I mean, is the issue of aggregate potentially an issue along the frame or the pendulum or whatever for a degree of degradation on that scale of harms claims threshold? And when do we tip over from into harmful interference from aggregate.
Well, that happens to be exactly the situation in the 1695 to 1710. You have the situation where you have LTE handheld units. Millions of them will be deployed ultimately. And the question is, for any other user of the spectrum, what's the aggregate interference that's going to occur? And do you have an analytical method to actually calculate it? Well, the analytical method is no small task. I mean, you're making hundreds of millions of calculations in order to build up and define what the aggregate is and what the effect will be on the users of that particular band, which happen to be government, Department of Defense, Department of Interior, and the Department of Commerce, largely receiving information from satellites. So as you are taking an Earth station and looking at the satellite on the horizon, and you capture that information from the satellite going over all the way to the loss of signal, and then you try to figure out around this particular site there may be 6 or 7 million handsets in a big, huge area. How do you calculate every single position over there? And then just say, well, how many satellites? Oh, I got, a dozen ultimately. And how many Earth stations do I have? Oh, 30 or 40. How do I handle that mass from an analytical point of view? And that's the question, how one does that.
Yes.
I mean, there's no doubt that there's going to be that effect, but how does one do that?
I was just going to say, Tom Dombrowski, my colleague, and I were talking about this issue this morning, and he was telling me this issue is a problem that we don't have good baseline for measuring. And so the question is, are we going to assume the worst case scenario, and this is going to go right to Pierre's heart?
No.
Or are we going to use your Monte Carlo analysis to come up with realistic modeling of how much uses how much at a particular time? Is it a peak and valley? Are we going to look at the peaks
Are
or
you
the
looking up
valleys?
versus looking down?
Yes.
Yeah.
So we have to get some level of agreement on that modeling, which is something that Tom's been doing for a while, working through the Spectrum Management Advisory Committee, Commerce Spectrum Management Advisory Committee.
So it's, these are new issues that we have with sharing, along with the issue of the unlicensed emitters that are out there, with both the unintentional and intentional and the embedded base we have of consumer grade devices, particularly in some of the lower frequency ranges. There's been a number of folks that have indicated that the whole issue of unlicensed devices and consumer-grade devices oscillating and failing, being one of the biggest challenges for enforcement that we have to face going forward. And with the reorganization of the FCC's Enforcement Bureau, one of the questions folks have is, well, what are we going to do? Does the FCC have enough staff to be able to go out and do it? Is that the government's role? Should the government be going out and resolving interference when you're dealing with consumer-grade devices and it's an unsophisticated individual that just happens to have a device? So, those are challenges that we'll be facing, and I'd like to kind of throw it open to the group and see what your thoughts are on that, how we might be able to face that and resolve those.
Well, the modernization is still ongoing, and the order also calls for our focus of the field to be in spectrum interference and resolution and mitigation. So allowing us to be focused on that core subject will allow us to free up some resources. But to the point being that shared spectrum, if that's the model we're going into, it tends to be kind of rather resource intensive. If we look at the 5 gigahertz band, you have with the meteorological aids along with the radio navigational radar, coexisting with the unlicensed devices. So you have mixed services, and trying to differentiate which one may be causing interference and which one is not is certainly a challenge. And it kind of brings to mind a comment that Dale's been hitting home for a while on the use of call signs. Being able to identify these unlicensed devices. So again, going back to the 5 gigahertz model, you have, the SSID, what you use to log into your Wi-Fi router. You may have your MAC address. Those may give you some indications of who the operator device, but not necessarily an absolute. So in the Commission's Spectrum Frontiers, RNO and further NPRM, we're actually queuing up the digital station identification in the millimeter wave, where the Commission's asking, should these devices broadcast some sort of call sign, digitally encoded, of course, and being able to be demodulated. And if it should it be all devices? Should it just be the unlicensed devices above a power level? And if so, who shall maintain the database? So I think that's important, is to being able to identify these devices, and that will, I think, increase our efficiency.
Any other panelists want to talk about that one? Otherwise, I'll go on to the next question, which I think he's kind of teed up, which is, once you've identified these devices, and the FCC's Enforcement Bureau has a significant history of having identified a number of different devices that they found in consumer homes and the LED lights and all these different things, we don't have a very good database of what those devices are. And so there's questions that are coming as to how do we compile and gather and make available data for academics, for industry, for government, to be able to look at these interference sources and be able to aggregate information, to be able to do trend analysis. So the questions then throw to both the FCC and to the carriers themselves. When you've identified sources of interference, how can you share the data that you have, and how can the FCC be more transparent about the data that they have, to be able to make it easier for us to be able to have a better baseline than we've got right now about what's out there and what's causing interference?
So you're looking at me. I mean, I have to say, we have had many instances where, the field office has been very helpful for resolving some major interference issues we have. But it's hard for me to imagine that we would want to be reporting on a regular basis all the interference that we deal with. I mean, I don't see how that's really going to happen. But maybe we'll be told we have to.
Potentially ways to protect the proprietary aspects of the network, but still sharing information on interference sources?
I'm not even sure it's so much, protecting, that is a piece of it. And, it's funny, we've talked about this before. It's also, to make sure people are aware of the sort of scope and the size of this. But it's also, it's just another, a burden, a reporting burden, that it's, you kind of have to look at it and say, I understand the interest of having, people be able to look at all of that data, but I'm not sure to what end, it would be, effective or useful.
Yeah, I think the concerns, so the TAC actually did a report where they talked about these concerns about the data, and there were a few concerns related to collecting the data. One was the competitive effects of carriers providing their own data. And again, we're talking about voluntary data reporting, so when you've got concerns from the ones that are going to report the data, that's a bit of an issue. The second was the privacy concerns about the actual ability to mine the content or the location of the individual users. And the TAC talked about the possibility of using a third party to aggregate that data, in particular talked about the SAS, spectrum assignment.
Right, the...
Tom, what's the spectrum assignment?
Spectrum
access system. Thank you. Spectrum access system administrator. And right there, you already have a competitive concern, because some of the spectrum assignment,
you can call them SAS.
The SAS, thank you, are actual competitors of the folks that are going to be providing their data. So right now, I think you've got a little bit of a trust issue before you're going to see a lot of folks that are going to voluntarily wish to provide their data, and you're going to have to find a way to address, I don't mean you, Rebecca, by the way, a way to make it so that it's anonymized and protects the competitive concerns and protects the consumer privacy concerns that go with these types of reporting. Never mind the concerns about reporting something to the FCC that may come back to haunt you down the line, which honestly with this enforcement bureau could actually also be a significant concern.
When I think one of the, when I was in the Enforcement Bureau, I was wishing that we'd put more information out about what the devices were that we were seeing. But one of the concerns that raises also is, so we've identified one device, and but you know, is it fair for us to be able to provide information about that particular device when it may just be that that one was, you know, had an issue. That one particular device failed, but that didn't mean that that manufacturer or that series of devices. So, you know, how by reporting we could inadvertently impact the market in a way that would be inappropriate too. So.
Yeah, and I think a lot of the interference mitigation, certainly on the commercial side, is done by the carriers and other licensees, and I think a vast, significant amount of that is data that presently the Commission doesn't see because it's not essentially acted on as a complaint. So the data we have now is probably of a very limited, small data size of the entire universe of interference activity that's occurring.
You see the big ones, like the time we had a booster blackout, Lower Manhattan in New Jersey. That one you saw.
Right.
So,
yeah.
But typically the smaller ones were just, that's what our network engineers are doing.
Well, you have a number of problems relative to data. First of all, the 20 million or so licenses, you can just go on the FCC website. And if you want to grab the information off of there, you can. Now, is it sufficient information for you to make appropriate calculation, some technical aspect of it? Well, that remains to be seen. Also, how good is that data? Maybe it's old data. Maybe people have forgotten to update the data. Maybe it's not located where it says it's supposed to be located. Or maybe they're not exactly operating on the frequency they are supposed to be operating on, and so on. So there's a whole bunch of things. Once you get the data, what is it that you really got?
And how valuable is it?
And
right.
As far as the government, I mean, obviously we don't want to expose all this information that protects us. So it's limited as to how that data can be made available. So you're left with the choices of going to the Commission with your problem or going to NTIA with your problem and saying, what do you think about it? Tell me whether it's good or bad, and maybe I'll have to sign a non-disclosure agreement when I take a look at whatever it is. But that's something that one sort of has to work out. It would be great to have an easy answer for this, but it's so far an unsolvable problem. But nevertheless, there's groups like the CSMAC that have some visibility into that area and have come up with conditions under which sharing would be amenable, even though we don't know exactly who the parties are from a technical point of view. But it's enough to.
I have to move us on because I realized that we're running out of time, and I haven't gotten to the questions for the audience yet, and particularly from any of the students, because we know we have to follow the WISER rule and ask if there are students that have questions first, and then we'll ask Dale if he has any comments, and then we'll go to audience questions if we have time, because I've got a timer in the back that's going to try and keep me honest here too. So I don't know the students well enough, so. Okay, oh, yes, right, yes.
So one of the.
Do we have a microphone, please? So that for the purposes of posterity.
So one of the assumptions that was made was that interference disputes are increasing because the amount of users are getting tightly banded together. I'm curious if in your experience you're finding that to be true. Is that something that's constantly happening? And if so, do you think that will affect how well you're able to solve these disputes amongst yourselves without going to the FCC for enforcement?
Yeah, that's an interesting question. I think, let me think about how to really, what we are finding, and it's the disputes, if you will, were really, we were talking about, what I was talking about is, licensee to licensee. I don't really see that, that just has become in some ways more complicated, because there are more bands. But what's interesting is, for example, the 700 megahertz band, we actually bought the entire United States, so we didn't actually have to worry about at least adjacent. No, and it's a serious issue internally. It's like they hate it when, I hate to say this to the FCC, but they hate it when they do small licenses because it just creates, more and more boundaries that we have to deal with. So in some ways, it's, some of those issues are actually created by the regulatory process. But what was interesting, to your point, in certain frequencies, and somebody will have to keep me honest here, I think there is a tendency for them to be in much more in the lower band frequencies. For example, when we deployed N700, we ran across a lot of things that we just weren't expecting. And I alluded to one, the type of the LEDs and things like that, we knew they were out there, but they were kind of a surprise to us. So, yes, that's probably an indication. What that to me is very interesting. It's an indication of things that are going on in other regulatory areas to move the country to be more, have fewer environmental impacts. And it's actually having, the same thing with fluorescent bulbs and the other thing, it's having an RF impact. So I know that isn't exactly an answer to your question. Might be an interesting paper.
And all that goes to the question of what the noise floor is and what sort of embedded base exists in these new bands that we're now moving into. I mean, are there devices that are emitting in those bands or not? And unless we do more research and measurements, we might not know those.
Or devices.
Right.
Yep.
Is there another student question?
There's a hand up in the back.
Yes.
Could you identify yourself, please?
Hi, my name is Ariel. My question is how this discussion and where it fits into the Spectrum Frontiers proceeding and what challenges or opportunities that proceeding created for the discussion about interference.
Well, I think a lot of the lessons learned that we have been learning through the spectrum sharing that has been engaged in for the last number of years, particularly when the AWS-3 bands, the 3.5 gigahertz bands, and all the work that both the Technological Advisory Council, the FCC, Pierre's work, Dale's work, the CSMAC's work, trying to figure out how different systems are going to operate together when you've got different sorts of systems, different modulation techniques, and different, and because that's all new.
Yeah.
So we're going through those growing pains right now. We're figuring all of this out now, and I think the lessons learned and the successes that we've had and the efforts that we're putting in right now are just going to benefit all the work that we're going to be doing up in the Spectrum Frontiers.
And one thing I would add to that too is you're talking about the propagation characteristics in those bands actually do create, they make for a different type of sharing environment. And the issue of aggregate interference into satellite is being dealt with there. But in fact, there's a lot on the record to talk about that the commission just decided not to do anything on it. But it is a lot of what you were saying, but I think we're going to have to look at it a little bit differently because of the propagation characteristics in the band.
Dale, do you have any comments that you want to wrap up with? We have less than two. Okay. Yeah. Well, I just got a 2-minute sign, but okay. But if we're out of time.
Yeah, we've got 2 minutes. Is there a question? And please identify yourself.
Richard Bennett, High Tech Forum. So the overall 50,000-foot impression I get from the discussion is there's still a pretty huge disconnect between the way that spectrum engineers and standards developers understand risk and interference and the way that regulators understand them. So how do we close the gap?
More forums like this.
What gap?
More collaboration.
Yeah, I don't know. I think I think that's correct in part, but Richard, I also think it is there is more of a movement toward a more common understanding of these things. And certainly the work that the TAC has done and the CSMAC both, have helped in that, as well as this forum, which has led to work that the CSMAC and TAC have done. So.
Yeah, I was going to say that this is addressed in the TAC report. The fact that there is a difference of how regulators look at it versus how engineers look at it. But I can't remember which one.
Well, and in fact, it was the.
In the modernization one?
Well, that and the FC, or the Technological Advisory Council document that was appended to this conference was about creating new enforcement mechanisms and creating an architecture for that. And I think that goes to some of those questions, is how do we pull the information from both the technical community, the engineering community, the industry, and the regulators together to be able to form an enforcement architecture and framework that will actually be successful and get us where we want to go as a community.
And if I could just cap that up by saying this is what's so important about having some type of certainty and clarity in how the systems are devised and how the devices are manufactured.
And transparency.
And transparency, right.
Right.
Very good. And the mark of Silicon Flatiron's panel is we always wish we had another hour at the end of the panel. An excellent panel. Please join me in thanking them. We'll have a break until 2:30, and then we will resume. Thank you.